If you have a will and you think your family is covered, this video is important. A will does not avoid probate in Alabama. A lot of people don't know that, and that changes everything about how you need to plan. I am Dee Asthana with Southern Estate Lawyers. I'm going to walk you through what a will does, what a trust does, and why most families need both, and what a complete plan actually looks like. Let's start with probate because that's what this is all really about. Probate is the court process that settles your estate after you pass away. In Alabama, it usually happens in the county in which you resided before your death. The court validates your will, appoints someone to manage your estates, pay your debts, and ultimately distributes what's left. For a simple estate, it takes between 6 months to 2 years. During that time, your assets are frozen. Your family cannot access them. During that time, it is hard for your heirs to manage, control, or even access your assets. There are attorney fees, CPA fees, court fees. Everything you own is public record, and everyone can know what you had and who got it. And that's why families want to avoid probate. We have families that call us who are shocked to learn that their loved one's estate had to go through probate even though they had a will. The will told the court what to do, but the courts, they still have to be involved. And that's the part that most people miss. So what does a will do and doesn't do? A will is a document that says who gets your assets after you die. In Alabama, a will has to be in writing, signed by you in the presence of 2 witnesses who also sign the will. Ideal scenario is that there is a notary public present who also notarizes the will. A will designates who your beneficiaries will be, what they get, appoints a personal representative for the estate, and critically, it's a document where you can name a guardian for your minor children. That alone makes it essential for parents to have a will. But a will does not avoid probate. Every asset subject to your will goes through probate before your family can receive it. And that is not a flaw in the process, that is exactly what a will is designed to do. A will also has no effect on assets that have payable on death beneficiaries. For example, your bank accounts, your life insurance, your 401ks. Those assets will transfer to the payable on death beneficiaries listed on those accounts, irrespective of what your will says about them. So what does a revocable living trust do? A revocable living trust, if properly drafted and funded, is the tool that helps you avoid probate. Here's how it works. While you're living, you transfer ownership of your assets into the trust. For example, your house. You stay in control. You are your own trustee of the trust, and nothing changes in everyday life. But when you pass, the successor trustee that you name in the trust steps in, and that trustee can now distribute the assets pursuant to your directions in the trust. No probate court, no delay, and no public record. The trust also takes effect the moment you sign it. So if you become incapacitated before you pass, your successor trustee can still step in your shoes and take care of you without a court getting involved. But here's the part that people miss the most. A trust only controls the assets that are inside it. If you sign a trust but don't fund it properly, for instance, if you don't retitle the house in the name of the trust, well, that house is still subject to probate. In a nutshell, your trust is only as good as the funding behind it. One of the most common situations we see with trusts is family calling when their loved one has passed. What do you mean? He had a trust. Why do we have to go through probate? Well, that's because the house was never retitled into the trust, or the house was sold and the new home that was purchased was never put into the trust. Drafting the trust is only half of the job. Making sure that it is properly funded is key, and that's something we walk every client through. We ensure that the trust is funded correctly. So, do you still need both a trust and a will in Alabama? For most families, yes, and here's why they work together rather than one replacing another. Your trust holds the major assets, like your real estate. Those pass directly to your beneficiaries without any need for probate. A will that is used alongside a trust is called a pour-over will, and it catches anything that wasn't transferred into the trust. Any property that you acquire later and you did not place it into the trust, the pourer of a will catches it and pours it into the trust. An important thing to note is that if you did forget an asset like that and didn't put it in the trust, that will still have to go through probate. Also, it's worth mentioning that the will is the document you use to name guardians for your minor children, so it's important to have the will alongside your trust. Rounding this out with a durable power of attorney, a healthcare directive, now you've got a complete plan for your family. 4 documents that cover your assets, your family, and your health. Typically, if you're a family that owns multiple real properties, and specifically if you own real properties in multiple states, you should really consider a trust for your estate plan. So here are 2 questions we hear a lot. I already have a will. Isn't that enough? A will is essential, but if your goal is for your family to receive the assets without having to go through the probate process in Alabama, a will alone will not get that done. You need a funded irrevocable living trust for that. Another question is a trust only for wealthy families? No, a revocable living trust makes sense for anyone who wishes to avoid probate and owns real estate. Whether it's one home or multiple real properties, Alabama probate can take more than a year and cost you thousands of dollars. A trust is a practical tool for everyday families just as much as it is for wealthy families. Most families that go through the trust process will tell us that it was a lot smoother than they thought it would be. And after their passing, their loved ones will tell us just how thankful they were that their parents had that plan in place. Estate planning in Alabama does not have to be complicated. For most families, we can come up with a plan that works in one consultation. We help families Alabama-wide. We have offices in Foley, Mobile, and Birmingham, and we offer virtual consultations for those that are not able to come see us. So if you're ready to talk, call us at 205-990-7000. You can also learn more about all things estate planning on our site, southernestate.lawyers.com, which also allows you to make an online appointment. So if this video was helpful, please like and subscribe to our channel. We put out practical estate planning content for our Alabama families all the time. And if you have a question, don't forget to drop it in the comments. Thank you for watching, and we look forward to working for you.